My name's Ian Corbett. I'm a solicitor and partner with Hopkins. I head up the Personal Injury and Medical Negligence Department here at the Eden Court Office, and today I'm going to talk about medical negligence claims. Well, there's two hurdles we have to overcome. Firstly, we have to show that the care you've received from your GP, your consultant, your dentist, the nurse or whoever is substandard. That's not straightforward because it's not good enough to show that with hindsight mistakes were made, or that in other areas of the country doctors, GPs, consultants or whoever would have treated you differently. We have to show that the treatment was negligent. In other words, that no reasonably competent medical practitioner in that field would have acted in that way, and that's called the Bolam test. If we can get over that hurdle, we then have to show that that substandard treatment has damaged you. That's not straightforward because people go to see doctors, nurses or whoever because they're ill or injured, and just because they haven't recovered or they've got worse doesn't necessarily mean that the treatment was substandard. And so to get answers to those two questions, we have to go to independent medical experts who will assess the treatment you've received and what damage it's caused. I usually advise my clients, if we've got enough time, to lodge a complaint first rather than jumping straight in with a legal claim. There are several reasons for doing that. Firstly, often the facts of what's happened during treatment are not clear, and so by lodging a complaint we get the GP practice or the hospital's perspective of what went wrong, so we know in advance what their defence to your claim is likely to be. Also, very often the dates are a little unclear. You may not remember the dates of particular appointments, so in that way we'll get a clear chronology. And finally, sometimes the patient just wants an explanation of what happened. At the end of the complaint process they may be entirely satisfied that the treatment has been proper, but previously it's not been explained, and so they go away quite happy and can avoid the trauma of going through a lengthy legal process. There are time limits for pursuing both complaints and starting court actions. With regard to a complaint, generally you have to lodge that within 12 months of the treatment you're complaining of, although if you've got a good reason for not being able to lodge your complaint earlier, usually hospitals and GP practices will accept the complaint and investigate it. There's a 3-year time limit for starting a court action in any compensation claim, but in the case of medical negligence actions, it's rarely the date on which the treatment occurred is the start date. Usually it's a bit further down the line, so it's the date upon which you knew or ought to have begun to think that the treatment you received might have been substandard. Medical negligence actions tend to be hard fought. They're not as easy to pursue as road accidents or accidents at work, but by and large, if you have a strong case, it is likely to settle. Yes, if we feel your case is a worthwhile one and can be pursued successfully, we will take it on a no-win, no-fee basis. That means if the case fails, you pay nothing. Contact us by telephone. We'll arrange an early appointment and we can discuss the case in detail with you. We can help you pursue the complaint process if you need help drafting your complaint letter, and then we can take the case on for you and proceed from there.